Good afternoon, good morning, everyone, and welcome to this first Masin organized webinar as part of Paris Arbitration Week. As you might all be knowing, Paris Arbitration Week is one of the most prominent events wherein all the professionals related to international arbitrations, be it construction, be it financial disputes, etc., come together to have a full 1 week of discussion on various issues which are of interest to the international arbitration community. So as part of the Paris Arbitration Week, we have, as Mason, organized our first webinar, which is related to construction disputes in specifically focusing on Middle East. Along with me, I have a stellar panel consisting of three most renowned professionals dealing with construction disputes and arbitrations in Middle East as well as internationally in other countries. So let me not take much of time and introduce the panelists, and then we go to discuss the various issues. The topic of today's discussion is how construction industry has been affected by COVID-19. Everybody knows that for last 2 years, COVID-19 has been playing havoc, not only on the personal life, but also on the professional lives. And, like every other industry, our industry, which is construction industry, has also been affected majorly and heavily by COVID. So we will discuss as part of this webinar what are the things which are affecting COVID-19 related issues and claims which are affecting the construction industry, specifically in Middle East. What are the typical claims related to COVID-19? What are the local laws? How both contractors and employers can handle the disputes related to COVID-19, and what are the best practices? So let me introduce the panel first. My name is Rohit Singhal, and I am the Chief Executive Officer of Masin. I am the expert on this panel. I act as delay and quantum experts in various international arbitrations related to construction. Along with me, I have got Mr. Ferré Hermann, who is partner in Curtis Mellot, Office of USA, New York. Mr. Ferré is partner in the Litigation and International Arbitration Group. His particular areas of experience includes energy, construction, business law, and international law. He has represented US and foreign government officials in state and federal proceedings and acts for sovereign states and international organizations in international arbitrations. He has arbitrated under American Arbitration Association, ICC, and ICSID, Dubai International Arbitration Center, SIAC, and United Nations Commission on International Trade Law, etc., and has worked on cases in Latin America, Middle East, North Africa, and Central Asia. Welcome, Mr. Ferré, to this webinar. Then I have with me Mr. Thomas Williams, who is partner in Sultan Al-Abdulla, Qatar. Thomas is an English qualified barrister and leads the firm's arbitration practice. Prior to joining Sultan Al-Abdulla, he was head of arbitration and commercial dispute resolution at the London office of an international law firm. He is an experienced advocate in arbitrations under all of the major institutional rules and in ad hoc arbitrations, and has also appeared regularly as an advocate in the English High Court, including the Commercial Court and the Court of Appeal. Thomas has particular experience of complex commercial disputes arising in the fields of energy, oil and gas, banking, financial services, construction, and engineering. Much of his work involves cross-jurisdictional issues and the conflicts of law such as asset tracing and the enforcement of judgments and arbitral awards. He has substantial experience in international cases and frequently works with overseas lawyers in common law and civil law jurisdictions. Thomas is a graduate of Cambridge University and was called to the bar in 2002. Welcome, Thomas, and thanks for joining us in the webinar. The third panelist with us is Advocate Ali Zarooni. Mr. Ali is the managing partner of Horizon and Company in Dubai. Ali is the founder and managing partner of Horizons and Company law firm. He is a highly accomplished and meticulous lawyer, having practiced law for 20 years. His area of specialization is primarily litigation and arbitration, with a proven track record of success in dispute matters. He has represented some of the most prominent companies, establishments, and individuals before all levels of courts and various arbitration tribunals. He is a qualified arbitrator, registered with DIAC, and is licensed as a private notary public by the Dubai courts. Welcome, Mr. Ali. So, ladies and gentlemen, let me now start with the topic of our discussion, which is COVID-19 construction disputes in the Middle East. As part of this webinar, basically we are not presenting any or giving any presentation. It's more of a chat wherein I'll be putting up questions to the panelists. And then in the end, I will also be taking up the questions which are going to be raised by the audience. The audience can put down their questions in the chat box, and in the end, we will take up all those questions. So, as I've already explained, COVID-19 has played an havoc on in every part of the world, including the construction industry. So let's see what are the various claims, disputes, and issues which have affected the construction industry pertaining to COVID-19. To begin with, Thomas, the first question which I would like to put to you is, under Qatari law, because you are based out of Qatar and expert on Qatari law, is COVID-19 is going to be treated as force majeure, and or the Qatari law is dealing COVID-19 under a separate format of law, like impossibility, frustration, change of law, or what? Over to you, Thomas.
Right, thank you. Well, I think those questions can be sensibly treated together. Can COVID-19 be treated as a force majeure event in a construction contract under Qatari law? The answer to that question is yes, it can. And there are two routes to that. The starting point, as you might expect, is the terms of the contract. And you need to see whether there is a clause in there known as a force majeure clause. And the second inquiry would be whether that force majeure clause contains COVID language, by which I mean words like pandemic, global health crisis, or similar language. If that is not the case, then all is not lost, because you have recourse to the general law and the specific provisions of the Qatari Civil Code, which give you a remedy in a force majeure type situation. And really the starting point is Article 187 and Article 188 of the Civil Code, which deal with impossibility of performance, because this is what force majeure is all about. It's the contractor saying, I can't perform because it's impossible to do so because of an unforeseen, an unforeseeable event. So dealing with 187 and 188 together, because they can be conveniently dealt with in that way, they provide that if the execution of a contract does become impossible due to an external event, then the contract is annulled. And if it's partially impossible as a result of that event to perform, then annulment takes place pro tanto, so only to the extent of the impossibility. Article 704 is also relevant. And that article provides that if a contract is impossible to perform, then the contractor has the right to say to the employer, please reimburse me any costs which I've incurred, and I also want the wages which are due to me. Article 1712 is also relevant. And this is what I like to call force majeure light, as opposed to force majeure with a capital F and a capital M. And what this deals with is not a situation of impossibility of performance, but rather more burdensome performance. So it's not that it's impossible, but it's simply much more difficult to perform. And what that provision says is that if, open quotes, general exceptional events occur, close quotes, as a result of which execution of the contract becomes unduly burdensome, and this is important, and it threatens the contractor with massive loss, so you need to show both of those ingredients, then what the judge or the arbitrator as appropriate can do is to restore what is otherwise a burdensome obligation to an obligation which is more reasonable. An important counterpoint to all of that is that under Article 700 of the Qatari Civil Code, if primary materials or wages become more expensive, that does not affect the overall obligations arising under the contract for the purposes of the approach of Qatari law. So just because it's more expensive in terms of paying your workforce and primary materials increase as a result of a force majeure event, that does not, in fact, entitle you to relief under the Qatari Civil Code. There's also Article 256, which is worth looking at. And what this says is that a debtor, and this is the way that it's put in the code, a debtor is exempted from paying compensation if he fails to execute or delays in executing an obligation, if that failure was due to an external cause in which the debtor played no part. So what I've sought to do there is to say, yes, you can get relief under Qatari law if you face a force majeure type situation, either because there's a force majeure provision in your contract, which is phrased in such a way which means that it must necessarily bite in a pandemic type situation. But failing that, you have recourse to the various provisions of the Civil Code, either force majeure proper or force majeure light, as I put it, which might be able to assist you. Annulment, either total or partial, is the remedy, but it comes with the important caveat, which I've explained under Article 700, which proceeds on the footing that under Qatari law, an increase in the price of materials or wages is not deemed to be such as affects obligations under the contract, so as in turn to correspond to a force majeure event. So with all that said, I will hand over to the next person.
Thank you, Thomas. Thanks for this. Mr. Ali, now over to you. You have heard, Thomas, how COVID is being treated under Qatari law. What are your views pertaining to the claims and disputes related to COVID-19 under UAE law for construction industry?
Sure. Thank you, first of all, to give me this opportunities to be with the prominent panelists with us here. The laws always is very similar on the region between UAE and Qatari laws. UAE is because it's very dynamic cities or countries, they are development very quick. The matters of COVID when it started 2020, it was really bad on the construction. Why? Because one major reason it was the government, they did not included the construction sector on those sector where they have to stop the work. So there is a lot of other sector has been instructed to shut down their operation till they look at the COVID situation. Construction was a different situation. It has been still work there. So what that means, it's create lots of burden on the contractor, because there is lots of requirement for the COVID was not even put it on the contract, was not even on the mind of the parties to put it in their contract, because it was something which is an exceptional issues. So UAE also, as other Arab countries and GCC, they have clauses which is 273 of civil transaction law. It's already mentioned about talking about the force majeure, and there is another article which is 249 on the same law, is talking about an exceptional circumstances. In UAE, there was some judgments came on. So the law has not been changed because the law is already there. So it can cover the situation. The debates was whether treating the COVID as a force majeure or it is an exceptional circumstances. And both of them, it's make one major difference. On force majeure, any contracting party, they can terminate their contract because it's force majeure and they cannot perform. So the performance, it is impossible. In exceptional circumstances, that doesn't make the parties not to do. They can do that, their obligation, but it is more tough, more expensive. It requires lots of other measures they should take it. So it will be more burden on them, which it was not even a part of their studies when they priced it for this project, for example. So there was some judgment, which is the court. They decided that the pandemic, it is an exceptional circumstances. It is not a force majeure. So, and we have that across the board in construction, on lease part, a lots of other courts. They already identified that the pandemic, it is unforeseen, but it will not make the obligation, it's impossible. So the parties still, they can do it, but the cost is different. The obligation is more hard. It will require more time. So the most of that decision came from the court is saying it is an exceptional circumstances, which is as per Article 249 of UAE law. So that is, it was very rapidly on last year, the court, they already issued a decision because the people was panic. We have a lot of projects in UAE. Contractor has a lot of pressure. Employer also has a pressure to complete. They need to know. So the court, they already was very rapidly deal with that, and they already decided. So it's not force majeure in UAE. It is the COVID has been treated as an exceptional circumstance.
Thank you, Mr. Ali. So that's quite exciting to know that there is already a decision by the court related to COVID-19 issues, because unlike UAE, many other countries still, the issue is not yet, has not yet matured enough for the courts and tribunals to give a decision that how COVID-19 is going to be dealt with. But that's great news, I think, both for the employers and the contractors. Now, over to you, Hermann. You have heard the Qatari law position, you've heard the UAE law position. What is the position under common law? You are an expert on common law. What are your views pertaining to COVID-19? How is it being treated under common law?
So let me just say that in common law jurisdictions, and specifically in New York, also under English law, force majeure is a creature of contract. So we had over the course of last year an unfolding event which resulted in an initial phase of parties furiously going through contracts to see precisely whether this pandemic was covered in their force majeure clauses. Under New York law, the idea that force majeure is an allocation of risk between the parties. So this type of allocation of risk is normally narrowly construed, and therefore in most force majeure clauses, there's a list of the type of events that are included in the force majeure provision, and a party would need to argue that if, for example, a pandemic is not listed, that perhaps another event that is specifically listed is sufficiently of the same kind or class in order to fit within the force majeure provision. So if the parties have allocated the risk of an event such as a pandemic, then of course the contract would govern. Now, if a pandemic is not included in the force majeure provision, not all is lost. There are several common law doctrines that would provide a brief respite. Of course, we have this unfolding situation. So at the early stage, there was also, I think, there was not clarity as to how long exactly the pandemic would last and precisely how it would affect the parties. As we know, that short events might result in, simply a neutral event in which the parties then, the contractor would be entitled to an extension of time, and then the project resumes. An event of a longer nature, such as this, ends up resulting in significant damage to both parties. And then the question is, are there other doctrines that might be available? And certainly there's a common law doctrine of impossibility. And certainly under New York law, the question is whether the performance is objectively impossible, not subjective to the particular contractor. And then if in fact performance is not impossible, it is possible but with significant hardship, then there are other doctrines as well. There's the doctrine of frustration of purpose, and this would be a circumstance in which an unforeseen event such as this certainly would substantially affect one party's expectation of the bargain that he entered into in the contract, and therefore this might be a basis for excusing performance. Another doctrine is impracticability, and it's somewhat related. And I just want to make one comment on this idea of rebalancing, because I think that there is a similar concept under common law, certainly under New York law, and that would result in once there is an understanding as to exactly what the new burdens are, it may result in a significant increase in cost of performance, but certainly that wouldn't obligate necessarily the employer to that new condition. So in other words, this does give an opportunity for both sides to consider, based on the new circumstances, whether the rebalancing is something that is going to result in an agreement going forward that they can agree to. Certainly, if the increased cost in performance is going to be, let's say, double the expected cost for the construction of the project, well, then the employer might have different plans, might decide to cancel the project altogether under the circumstances. I'll leave it there. Thank you.
I think that's quite interesting to know that, even if supposedly COVID-19 is not listed specifically under the force majeure clause, there are other issues and other doctrines which are available. So, Mr. Ali, is such a kind of, separate doctrines of impossibility, frustration, and rebalancing exist under UAE law?
Yes, and of course, it's already there, and it is already even settled previously when there was, before even COVID, the Article 237, paragraph 2 is talking about the situation, and even 249 of civil transaction. Both of them, they are talking about if there is unforeseen or an exceptional circumstances which nobody can avoid, and it make the obligation is more heavy on one of the parties, the court or the laws allow that parties to approach the court and request them to rebalance the situation. That is, of course, if they couldn't manage it amicably out of the court, they can approach the court and put a request, or by filing a case saying, we have this circumstances, which is not a part of a normal risk of our business, and which make the liabilities is much heavy, and which is make us a heavy loss, and we can't, then there is no balance in the contract. So the court in this situation will involve, even if there was a agreed liquidated damage or agreed penalties and others, still the court can interfere and balance the situation between the both party, employer and contractor, and to make reasonably the contract there is a equality on that, because you know always the contract is a contract. The employer always try to put lots of pressure on the contractor, but in the UAE that's settled long time. Even if there is no pandemic, but there is a different circumstances happen, you can still approach, and then it's happen, and it's already there is so many cases settled by the Court of Cassation in Dubai, in Abu Dhabi, High Court, Federal Court. It's already settling that concept. The court can balance the situation, subjected there is a clear evidence that there is unforeseen and exceptional circumstances which cannot be even think about it, or cannot be put it on their calculation before entering to the contract. Then the court can involve and balance the situation.
Thank you, Mr. Ali. Thomas, now over to you. You've heard Ferré and Mr. Ali talking about these doctrines which are different from the doctrine of force majeure to claim COVID-19 related time and cost. So under Qatari law, supposedly a situation is that, and which we have coming across as experts and claim consultants, that a lot of times the employers are saying that the word pandemic is not specifically listed in the force majeure clause. So therefore, we don't intend to give you any extra time and cost when the claim for COVID-19 is being claimed under force majeure. So under Qatari law, or what has been your experience to deal with such a kind of circumstance?
Thank you, Rohit. Well, if the employer tried to run that argument, it would be a bad one, and they would experience limited success with it, at least under Qatari law. The starting point would be Article 1712 of the Civil Code, which, as I've said, involves a rebalancing of an otherwise burdensome obligation to a reasonable one. And what you'd be saying to the judge or arbitrator is, well, look, it needs to be rebalanced such that I'm entitled to an EOT and additional cost. In terms of Article 256, which I've also addressed, it might be that you could pray that in aid, because although that's a provision that doesn't entitle a contractor to compensation as such, it operates in such a way that exempts the contractor from paying compensation if it's impossible or unduly burdensome for him to perform. So those, it seems to me, are the arguments in play.
Thank you, Thomas. Now, Ferré, you specified that there are different doctrines under common law under which COVID-19 issues can be raised. Now, let's assume a contractor is trying to put its claim for COVID-19, and typically force majeure clauses are saying only time and no cost. So in such a scenario, what is your recommendation? What should a contractor do, considering that he has lost money because of COVID-19? There has been delays and disruptions, which something was unforeseeable or beyond its control. So what is your advice? Should he say that this is my primary claim under X doctrine or under Y doctrine? What should be the way in which the claim should be put forward, when a contractor is working in common law jurisdictions?
So let me first say that because courts will enforce the parties' provisions. And if there's been an allocation of risk, if pandemic is included in the force majeure clause and the results of force majeure are clearly spelled out, then for example, a New York court would enforce that provision. In other words, the parties considered the allocation of risk and the results of, and in this case, let's say the force majeure clause specifically included what was to result in the event of a pandemic, then the courts will likely enforce the clause as written. So with all the consequences of that clause. Now, in common law jurisdictions, parties make economic decisions about whether to perform a contract or not to perform a contract all the time. So if it turns out that the result of a force majeure clause is so onerous on the contractor, has other possibilities. In other words, there might be termination provisions that can be looked at. But if the contract specifically spells out that in the event of a force majeure, the contractor gets additional time, but not additional cost, and the force majeure provision specifically enumerates as one of the types of events, pandemics, then I think the contractor is more constrained in the possibilities of what he might be able to do. If the force majeure provision, this is where, sometimes it turns out that the force majeure clause didn't anticipate pandemics, in which case certainly the contractor will not be arguing that it's a force majeure event and will be arguing something else, a changed circumstance that falls under some of these other provisions of the contract, such that the contractor would be entitled to an additional period of time and cost. And for example, there might be provisions regarding what occurs when an unforeseen event, changed circumstance occurs, such that now the work requires additional cost. It might be sufficiently included, or variation provision, for example, might be sufficiently broad that it might be included in there. So in the first instance, we have to look at the force majeure clause to see if it's there, and most common law jurisdictions would enforce the clause as written.
Thank you, Hermann. Mr. Ali, let's assume, we have come across such kind of a situations where, because there is no clarity as of now on COVID-19 legal implications and all, if an employer enforces and, puts a liquidated damage because of delay and, probably terminates the contract, but you have a situation where COVID-19 was there and part of the fault was also can be attributed to COVID-19. So in such a scenario, how do you think the courts in UAE are going to look at it? Will they be lenient, flexible, and considering the fact that there is already a existing decision which has come from them? So do you think that contractors can have some kind of a relief from the courts?
Yes, it is today because of the situations. There is lots of claims in the courts and in arbitration related to the COVID and between the contractor and the employer. So there is so many of the disputes resulting of last year COVID impact. Of course, today the court will be more lenient, more acceptable to the arguments subjected. Of course, argument of the contractor usually, because subjected the court, the contractor can show the evidence that all the delay, all the cost was because of the COVID, not because of their own acts, because there was a lots of projects running before COVID, and the contractor always was, or most of the time was late on their performance sometimes. So they cannot club it and they said, we have this COVID and then we need to be compensated for the whole period. They have to prove to the court that the only period, and the court will only take it only from the period where the COVID started and the lockdown started on the world. That is the period where the court will definitely look at it, because there was a lot of order came from the government for a lockdown, for a social distance, for a lot of rules, especially in the construction. They got a lot of badly impact because social distance result was you have to have more labor camps than a normal. You have a more transportation than a normal. A lots of labor, you can't get them back from their own country because there is no flight. So there is a lots of impact. The cost of materials is go up. These all, the court will be definitely today considering that. It is something that is unforeseen. It is not controllable by the parties, and it is cannot be even avoided. So the court today will be much lenient, and we have already a lots of cases going on the courts where the court actually very well understanding that points now. And we have an arbitration. Of course, the arbitration, I think, in my opinion, also it's make a big difference, because usually on the panel there is a good QCs which they understand the sector and they understand the difficulties. So we got a lots of very good response from the tribunals on a lots of cases which is we are managing now, and they was very understandable. And in some matters, even they order it for us to freeze or order the other parties not to liquidate the bond. So that's showing that the tribunals, of course, because of their expertise, they know. And then that's why lots of people, they like to go to arbitration, because there's a good expertise there. And they issue a lots of orders now to freeze it. So they are trying to balance the situation, not to put more burden. But also in the court, I can't ignore that today the judges also, they already looking at the matters in front of them. They're really understanding, subjected, of course, again, as a party, you need to prove it, because it's all about the proof. If you can't prove it, then it's only generally putting the arguments. The court won't take it. Even the tribunals also, they will need a proving evidence to that. But I think so the situation is much better today. The understanding is much better in the court. In arbitration, of course, much more than the court. But even the court, which is usually we have a tough time with them, but they are now very cooperative, very understanding.
Thank you, Mr. Ali. At this stage, I'll just change the topic and go to what is called a change in law concept and COVID-19. Thomas, as you are aware, because of COVID-19, there were a lot of instructions coming from the government, from the regulatory authorities pertaining to social distancing. Let's assume earlier a vehicle being driven at the site would have 4 to 5 people sitting inside it, but because of COVID-19, the number of people which are allowed to be traveling in one vehicle had reduced down to maybe 2 or 3. So do you think that such kind of claims which are owing to a loss of productivity because a vehicle cannot be used to its full extent, which is a typical example which I've given, can it be claimed under change of law, or you would still like the contractors to say that let it be claimed under either force majeure or the other doctrines which we have just discussed? Thank you.
Well, first of all, Rohit, you've got to assess the change of law provision in the contract. You've got to look at what the provision says, and in particular, in this context, determine who bears the risk for the time and cost impact resulting from the change in law. And from the contractor's perspective, it should bear the risk for changes in law to the extent of its own obligations under the contract. But if the contract states that the contractor is only entitled to cost and not EOT, then what the contractor could do is to rely on Article 1712 of the Qatari Civil Code, which we've looked at. And that is the provision which you'll remember is engaged where a contractor is threatened with massive loss, and there are generally exceptional events which occur and the obligations become unduly burdensome. And if those two matters can be established, then the judge or arbitrator can restore the burdensome obligation to a reasonable level. You can also seek to rely as a contractor on the contractual EOT provisions to assess if the impact of a COVID-related change in law can be classified as a delay event within the scope of the contractual provisions. So those points to me meet the question which you put to me, I think.
Thank you, Thomas. Mr. Hermann, what are your views, pertaining to such a kind of a scenario under common law?
So similarly, under the common law, a change in law would be, you'd look to see if there's a provision that allocates the risk. And typically it is a risk that is taken on by the contractor. But I want to come back to this, this doctrine of impracticability, which I mentioned early on, which would certainly govern here, where the manner of performance is now so affected by a change in the law that it is really impracticable to do the project as the parties anticipated. So that doctrine would provide some relief to a contractor, and a court would certainly consider the extent to which these new burdens imposed on the contractor have made performance significantly more difficult in terms of time and, of course, in terms of cost. Let me just say also that I know that in the GCC region, many contractors are managing laborers that come from outside the region. So there are significantly other burdens that to consider in the U.S. Certainly in New York, that is not one of the burdens, one of the considerations. So this idea of what do you do with potentially thousands of workers that are now paralyzed and not able to, they're in country specifically to do a project and now they're not able to perform. That type of extreme circumstance is not typically what we would see here, for example, in New York. So the idea, so I think that certainly if there were that type of extreme circumstance, I think that courts would certainly consider that, especially under this doctrine of impracticability. The significant additional cost of keeping, if in fact the contractor was going to be keeping a labor force in place to be able to perform or resume performance at the convenience of a project that the employer does want to continue, then I think certainly this doctrine and others would certainly inform a court as to how how the project should be considered fairly as between the two parties.
Thank you, Mr. Hermann. So Ali, you have heard both Thomas and Hermann talking about the change of law concept and the COVID-19 claims. So what is the scenario under UAE law? Can a contractor claim costs because of the government-related restrictions under change in law concept?
Yeah, we don't treat it as a change in law because the law is a law. Law is there. Nothing has been changed. It was very difficult to change the law. So what the government came is with an instruction. Government come with an instruction saying that this is should be a change, and this contract. I'm sorry, I have I think my.
So we have something, an unforeseeable circumstance. So we'll just wait for a minute. Okay, meanwhile, maybe once Ali joins, I'll go back to him. But let me tell you, from an expert and quantification perspective, we have heard the lawyers talk about how to claim. But what is most important is that whether the contractors are having sufficient and suitable documents to put up a claim related to COVID-19. That is very important. So I think Ali has come. So maybe Ali, you can continue.
I'm so sorry for that because my son seems he wants to be a lawyer very quickly, so he just wants to join here. So the government actually did not change the law, but they issue an orders to a lots of sectors for a lockdown, for a social distance, for labor camps. This all has been issued. In some other sector, even it was a fully lockdown. Of course, this all it is something which is beyond the control of the contractor, and they have to abide by this rules and regulations. So the instruction when this comes binding, the contractor has to follow that. If they follow that, then there is something will happen to the project, the delay, the cost, and everything. So they cannot be punished because there is a government which is their decision supersedes their control. And then the employer said, well, I don't care. You have to do it. Okay. So in this situation, of course, it has been recognized by the courts that it is a decision coming from the government. Nobody can break it and violate it because there will be a heavy fines against them. So they considering this all, and there is all the circumstances fall from that orders, which is like social distance, transportation, laborers, camp, and everything. This is all that has been considered.
Thank you, Mr. Ali. So I was just before Ali came back, I was talking about the documentation part of the COVID-19 claim. So, as quantum experts, we come across such kind of claims. And my advice to all the people who are putting up claims and all the engineers and employers who are reviewing the claim is that documentation is very important. It can be a scenario where a contractor might try to claim an extension of time, putting the attributability to COVID-19, but there is already a delay which is taking place because of contractor or because of other reasons. So what is most important is that the right schedules, the right documentation are maintained to highlight and to keep a record of what are the delays and disruptions which are taking place. For example, let's say 1,000 people were working at site prior to the start of COVID, and then during COVID there was a reduction in the manpower. So a question, and because of the reduction of the manpower, the progress will go down. So site records have to be there, manpower records have to be there. Similarly, equipment records have to be there. Then the schedules are going to be, the updated schedule should be maintained so that what are the impacts of COVID can easily be found out, because definitely there will be a scenario where the opposing party, which could be engineer or employer, might say that the contractor was already in delay and it is not COVID-19, but the continuing delay of the contractor because of incidents and delay events which are prior to COVID-19. So therefore, documentation is very important. I would suggest and recommend, please ensure that you have got the daily progress report, wherein you specify in case work is being done, how much is being done. the weekly and monthly progress report should spell out that there is an impact on COVID. It could be that the impact of COVID is limited to a particular equipment which is being procured from a country where still the lockdown is there, or it could be because of other reasons. So the monthly, weekly, and daily progress report should highlight those kind of things. A record of manpower, equipment which are maintained should continuously be there. COVID-19, still the impact is still continuing. Yes, things have reduced, but still there is continuing impact of it. So therefore, maintaining those documents is important. Updates of the schedule should be important, because tomorrow, if a contractor would like to claim prolongation cost or would like to claim an extension of time, these schedules are going to show that what is the attributability of the delay, whether COVID-19 was critical delay or was it some other incident which was causing the delay and was attributable and was causing an extension of time. So now going back to Thomas, to you, you understand that in a typical construction contract, notices are very important. Now, what has happened is in 2020, when COVID-19 started, it was kind of a sudden flux of issues. People were not prepared, and a lot of people have not issued notices which are required as per the provisions of contract, either force majeure or the other provisions of the contract. So, and still today, COVID-19 is continuing. Maybe if it is a big, construction contract where procurement is there, it could be that the material is coming from a country where still the impact of COVID-19 is there. So what do you see that in such a scenario, will the arbitrators and the court be slightly relaxed that this is something completely unforeseeable, and because of the circumstances, notices were not issued by the contractor as per the provisions of the contract, so therefore the claims related to COVID-19 time and cost would not be thrown out owing to the lack of notices?
Well, it would depend on the individual circumstances, Rohit, but in my view, the contractor should continue to notify the employer or the engineer of COVID-19 impacts or the continued effects of COVID. And the reason for that is because there's an obligation to do so under the obligation of good faith under Article 172 of the Civil Code. As you very sensibly say, it's also important that this is done so that the documentary record is complete. As you and I well know, the documents are really everything when it comes to these sorts of cases. And if the dispute does go to arbitration, then these contemporaneous records will support the contractor's position and be very important indeed in vindicating any claim. In terms of the frequency of notices, that would depend on any timelines given in the contract. If the contract doesn't say anything about the frequency, then you simply adopt a commonsensical approach and send notices at reasonable intervals. So for instance, if in the first instance a contractor claims that the pandemic has delayed its procurement activities by, say, 1 month, but the pandemic continues to affect the procurement process, the second notice should be sent at the expiry of that 1 month period, in my view. As for the details in any notice, in my view, they should specify the exact impact of the pandemic on the contractor's works, by which I mean they should specify which works have been affected, which activities have been affected, and they should also specify the likely time and cost impact and any mitigation measures that the contractor has taken.
Thank you, Thomas. Mr. Ali, my limited understanding of construction law under UAE is that generally the civil law under UAE is not very strict in terms of notices. So what do you see that in case a contractor has failed to serve his notices as per the provisions of the contract, and especially in light of COVID, will there be a scenario where COVID-19 claims of the contractor may be turned down, because of the notice provisions?
Of course, it's a civil law system. Civil law system always there's so many interpretation actually to the contract, and always they can go beyond and see what is the parties' agreement. Now, the notice it was not a vital always on lots of other cases we have it, but doesn't mean that there is no documentation. That is the most important, because you have to understand we are in the civil law system and the burden of proof on the claimant parties. So if you are claiming that there is you are entitled for extension of time or a cost and there is a delay, if you fail to prove that, then you can't, the court will not grant it for you. So of course you have to be cautious. Notice if it's not on the same time as per the contract, i.e., within a 20 days or within 15 days as per the parties, that's you can come cross that border and prove why it has not been done, because sometimes because of lockdown, so the staff is not there, the offices was locked, so we couldn't send it in the right time. The court will understand that because it's a civil law system, not very strictly on that. So, but it doesn't mean that you have no documentation and then suddenly you claim it that, yeah, well, I have a delay on supply this, I have a delay because of a labor force, and you did not even raise it that previously. So you have to have a document. Maybe it's not very specifically on timing, if it's a little bit different, but still the court, they will look at the evidence. So the evidence is very important.
Hermann, what are your views on notices during COVID-19?
So notice, again, it's in a common law jurisdiction, you would take a look at what the contract requires, and what the contract states are the consequences of because in many instances, the contract will specify what the consequences are of the failure to notify. So certainly if the contract specifies the consequence of a failure to notify, for example, that it results in the waiver of a claim relating to an event or circumstance, then that will be enforced. So certainly notice provisions in contracts, certainly in common law jurisdictions, should be followed, and in particular where they specify what the consequence is of a failure to issue a notice. In the context, for example, of a FIDIC form contract, where there's a requirement to provide a notice within a particular period, and then to provide substantiation, those types of provisions are enforced. And in fact, it's good practice for a contractor to be on top of certainly events and circumstances that it believes will result in a need for an extension of time. And certainly if there is an event or circumstance that will result in significant cost, it's good advice for the contractor to both notify and document the effects of that event or circumstance, so that the contractor is then in the best position to be able to assert the claim and prove the claim.
So, just continuing on this with you, Hermann, like typically FIDIC form of contract says notify as soon as you get to know within 21 days or 2 weeks, and followed by submitting the details, which is cost, time, and other details in next 42 days or 58 days, like that. So do you think that in the event the first notice is gone, but the second notice, which is submitting further details, is not yet gone because of the fact that, offices were shut down, the details were not available. So in that scenario, how can a contractor, come out of such a kind of a situation where first notification is gone, but the second detailed notification specifying time and cost implications has not been issued?
So certainly, if there are facts and circumstances beyond the control, for example, the offices were entirely closed and it was impossible for the contractor to operate. For example, the site office was shut down. In fact, in New York City, there were mandatory shutdowns of project sites. So that would be a circumstance in which, certainly for substantiation, where the materials and the documentation that would be necessary to provide that substantiation is just not accessible, I think that would be certainly something taken into consideration. So that would be, the time limits on substantiation would certainly be relaxed.
Thank you, Herman. So now I think I've got a couple of questions from the audience, which I'd like to take it up. So first is to you, Thomas. Like you have heard Ali saying that, the courts in UAE have come up with the decision related to COVID-19 disputes. What is the scenario in Qatar? Do you think that any of the courts in Qatar have come out and laid down, kind of a, precedence on COVID-19 disputes?
I don't know, Rohit, because I don't sadly appear before the courts or practice before the courts of Qatar, so I wouldn't know, I'm afraid. We are yet to marshal a COVID-related argument in an arbitration, but as and when we do, then we would surely pray and aid any or all relevant decisions of the Qatari courts that were on point. But I can't answer that question, I'm afraid. I'm simply not qualified to do it.
Okay. Thank you. Mr. Ali, the question is next for you. You said that the UAE courts have come up with the decision related to COVID-19. So will your recommendation not be to the, to the claimants and the contractors that let them put their claims with, under that provision of the law?
I can't get you, Rohit, because it was a little bit cutting. Can you just repeat it?
So I'll repeat. You told in the beginning of this webinar that there has been a decision from the UAE court on how to treat COVID-19. So would you recommend that the claimants or the contractors who would be putting up a COVID-19 claim should, use that specific, precedence which has been set by the court in order to claim, or should they still, have a look at their contract and probably use one of the provisions of the contract rather than what has been the court decision?
Sure. I think first they have to look at their contract. Now, if most of the contractors, their provision, it was not even foreseeing this kind of thing can happen, and which is based on our experience. So they can use that decisions when they negotiate with the employer and try to balance it. So to make the employer feel that it is worth to negotiate out of the court instead of going on litigating or arbitrating on the contract. So they can use the contract, but based on my experience, there is always very less numbers of articles or clauses that will help them, but they can use that for their claims. They can use that for negotiating, and then if it doesn't work, they have to save their rights end of the day, because there is effect happen to the COVID to all the sectors across the board. So they have to take it and take their rights, whether it is the employer agree on out of the court or in the court or in arbitration. I think so. That's what's my advice.
Thank you. Hermann, to you, there is a question which has come that one of the audience says that their bank guarantee was encashed at the time when COVID-19 was at its peak, citing issues which were partly of non-performance and partly of other things. So in that scenario, what would you recommend? Will there be a possibility to get a injunction on the encashment of bank guarantee, or will they have to claim their damages in one of the forums of arbitration or court?
Yes. So if there's been a threat of cashing, let's say, a performance guarantee, certainly seeking emergency relief is certainly what we would advise, and especially if it's because if the reason for non-performance is COVID, there would likely be a high likelihood of success that an injunction would be granted. Now, if the employer has already cashed a performance guarantee, well, and it's due to non-performance because of COVID, I think that there's a significant, this is potentially a claim for, bad faith encashment of the performance guarantee, and all of the direct harms as a result of that cashing of the performance guarantee would come into play. That would be that those harms are claimable then against the employer. And again, everything is really dependent on the specific facts and circumstances of the particular situation. But if it's purely based on non-performance due to COVID, I would say that that's an improper encashment of the performance guarantee.
Thank you, Herman. Thomas, the question is for you now. One of the audience says that, in Qatar, all these football constructions, stadiums construction is all going on. So what has happened is, because of COVID-19, there was a delay in the execution of works which were related to these mega projects of football stadiums. But after that, once there was some relaxation in COVID-19, the employer started pushing the contractor to mobilize additional resources, manpower, and equipment to expedite the work and to recover whatever has been the delays because of COVID-19. So in that scenario, under Qatari law, will there be a possibility that this contractor can claim acceleration, or the mobilization of extra resources, as under any of the provisions of Qatari law, and such a kind of a provision does not exist in the contract? Thomas, you are on mute. Sorry.
I think that's likely on the basis of the provisions that I've been outlining. Yes. To keep the answer short, yes, I do think that is right. Yes.
Okay, great. So now the next one is on me. In fact, there is a question which has been put to me, is that can you claim a loss of productivity because of COVID? And in case you have to prove that, what are the ways? So just to explain, yes, you can claim loss of productivity under one of the provisions which all the three lawyers have just been talking about. To prove that, you will have to do a loss of productivity assessment, which we call as a disruption analysis, to show that what was the productivity pre-COVID stage, what was the productivity during the COVID stage, and then compare and show that there is a causal link which exists related to the productivity loss which has taken place because of COVID. So yes, it is very much doable, but again, documentation is required in order to prove that loss of productivity, to establish the productivity pre-COVID and during the COVID stage. There are standard methods of doing disruption analysis, like the measured mile analysis or the earned value analysis, and some other methods are there. But again, documentation is important to understand what was the productivity per the resource, per equipment, per manpower pre-COVID stage, and what was during the COVID stage. And then you can compare to show that yes, a loss of productivity has happened, and specifically during the COVID time. So I think that brings us to the end of this webinar. I have got a lot of questions, but I would not like to take more of time. And I'm really thankful to all the three participants, Thomas, Hermann, and Mr. Ali, for being part of this and giving their insight and views on COVID-19. I'm also thankful to Paris Arbitration Week organizers and to all the audience who have been here to listen to us. Thank you. Thanks a lot.
Thank you. Thank you. Pleasure.
Thank you. Bye. Bye.